The defense attorney, Frank Policelli, who yesterday spoke with me and asked to respond to a few things that were said, and we'll clear that up once and for all here before we get done. But quickly, let's listen to what ADA Lori Lisi said yesterday in regards to the juror from the first trial saying that, well, let's listen and see exactly what was said.
That is that after the first mistrial, the judge talked to some of the jurors, and that was one of the things that they told the judge. You know, if we'd had an option of picking something lesser than murder, we would have considered it. And in fact, one of the jurors specifically told the judge, look, please communicate that to the prosecutors if they're going to retry this case again, that they should consider something else other than murder.
Right.
So
backwards.
So in that case, is it that would be kosher, right? That the juror said, "Please communicate this to the prosecution." What are your thoughts? Tight to the microphone, if you could.
Well, it depends on what happens after that. I mean, did the judge communicate that to the district attorney's office?
Well, the juror asked for that. Would that
he
be
asked
wrong?
for it,
right? Or she asked for that.
Whatever they asked for, that doesn't matter. It's what the judge does.
So it would be wrong if the judge communicated that to the prosecution?
I think so.
Okay.
After the trial or during a trial? Or does that matter, in your opinion?
Well, this was after. This clearly was after the
No,
trial.
I know, but I guess I think something you had mentioned earlier about basically sharing strategy or giving direction on how to prosecute a case.
Yeah, but he's the judge.
It would be out of bounds.
He's the judge, okay? He's not supposed to do that.
It would certainly be out of bounds if he did it during a trial. But if he made a comment afterward, you know,
it doesn't matter.
It
it's
doesn't?
supposed to be fair and neutral throughout, okay? You're not supposed to do that.
Well, but I don't think it would be out of bounds.
To tell him how to prosecute his case?
I don't think he's telling him how to prosecute the
he
case.
is.
I think he's passing
Let's say
on
he asked
something.
for a manslaughter charge. They indicted on murder. What are they saying? Go back to the grand jury and get a new indictment?
The judge has a ton of experience, obviously, and he's prosecuted cases before. He's not telling him, here's what I would do. He'd be telling him, here's what a juror said. Listen, I don't know, and I'm certainly not going to debate you over the law. But what I'm saying is, to me, they just seem like two different things. You disagree with that?
Well, this would be up for, and if you don't do the appeal, this certainly would be up.
Probably not anything to do with the appeal. Who knows? But,
okay.
Here's the thing. If they're saying that they wanted to go for a manslaughter charge before the second trial, then why didn't they let anybody know about it until the last minute?
When we asked Scott that on the air, he said that procedurally he's supposed to wait until the end. Is that
wait until the end for what?
To add the lesser charge. We asked him why it came 3 days before.
Well, yeah, that's when you request it. But
right, but he's saying, but
what I'm saying is that lesser charge should have never been there in the first place.
Had they
that's
charged,
where we get to the constructive amendment of the indictment. That's where we get into the no reasonable view of the evidence to support the lesser included, which is an argument that Mike Caluso addressed yesterday, right, that we know obviously we disagree with, and that's going to be a legal issue to be raised.
Again, from our standpoint, is we're not attorneys, so I thought the prosecution yesterday presented a very good case.
Oh yes, they're very good at it. But that's what. Look at this is my point. You argue about the facts and you argue about the law. They obviously are going to argue one scenario of the facts and the law. The defense lawyer argues another scenario of the facts and the law, and then the judge has to make a decision.
I truly believe when you're talking about sending someone away to prison for 20 years, I don't think there's any doubt that every one of those members of the prosecution that were in here yesterday believe in their hearts they got it. They got it right, and you would expect nothing else.
Oh yeah,
anything different. But I want to leave with these two things, though, for you to clarify. What was said yesterday is that you might have been undermining Chris Pelley. You say that is absolutely not true.
The opposite is true. Ask Chris Pelley.
And the opposite, and you believe he did a great job.
Yes.
Secondly, was the issue. Are you really worried that people are going to walk away and think that you're?
No. That's that's look. We joke around all the time like that.
Yeah.
But my point is this: when you're talking trial strategy in a criminal case, okay. And you ask other people, that was what was going on. Ask Chris.
Yeah.
You know?
Right.
This is why it's so ludicrous and insulting for the district attorney to make that kind of insinuation that there was something unethical or wrong going on when the opposite was
Right.
true.
And that's why I think when we talked yesterday, you said, I don't want to be talking about we're not talking trial, we're not talking about the details of the case.
exactly.
I want to talk about the disparaging remarks that were made
Yeah.
against me, and
Yeah.
that's why you're here today.
That's the only reason.
All right.
All right.
Anything else you want to add?
Nope.
It's cold outside.
Thank you, Frank.
All right.
All right. You are.